Somewhere inside every large company, there is a room where the decisions are made, where the documents are drafted, where the names are moved from one column on a spreadsheet to another. If you have been handed a performance improvement plan in the last 90 days, you need to understand something that no one inside the building will ever say to you out loud. The paper sitting in your inbox is not what your manager told you it was. It is a tombstone. It is the administrative record of a decision that was very likely made weeks or months before you ever heard the phrase performance concerns used in a meeting about you, and the document exists to put that decision on a documented timeline the company can defend. The PIP is sold as a lifeline. It is framed with warm language about growth, about support, about opportunity, about alignment. The document itself will often contain phrases like, "We want to see you succeed," and "This is a tool for your development." Much of that language is there to formalize a process the company wants to look fair on paper. Managers are trained to deliver it in a calm, concerned register. The meetings are prepared in advance, the pauses, the phrasing, the order in which concerns are raised. Your role for the next 30, 60, or 90 days is to participate in a process whose administrative purpose is your documented exit, while the room maintains the position that the outcome is still open. What you are actually living through is a paid interview period, and the interview is not for your current role. The interview is for the company's legal defense file. Every conversation, every email, every weekly check-in, every metric hit or missed is being logged, dated, and filed. The clock is ticking, and it is ticking against you, because the outcome the company has budgeted for is your exit. The PIP exists to make that exit legally clean, financially cheap, and reputationally quiet. Everything else being said about it is a performance, and the sooner that is understood, the sooner real protection becomes possible. What follows is how the machine actually works, piece by piece, because once the architecture is visible, the fog lifts, and the cold shoulder from the manager, from HR, from people who used to invite you to lunch, suddenly makes complete structural sense. The first truth is the one that explains everything else. The PIP is, before anything else, a legal instrument. In at-will jurisdictions, and the United States is the clearest example, the company does not technically need a reason to terminate an employee. It can simply end the relationship. But corporate legal departments learned long ago that at-will is a theoretical shield, not a practical one. A terminated employee can still file for unemployment, can still bring a wrongful termination claim, can still file a discrimination complaint with the EEOC, can still attract a plaintiff's attorney on contingency. Each of those outcomes creates cost. Each of them creates risk. The PIP is one of the primary documents companies use to reduce that risk. It exists to support what employment lawyers often refer to as the good faith element, the evidentiary showing that the company made a reasonable attempt to address the employee's performance before terminating them. In practical terms, if it isn't in writing, in most internal reviews, it didn't happen. That is the operating principle of corporate employment documentation, and the PIP is the writing. When the document arrives, the employee is not primarily being coached. The employee is being papered. The file is being built. And that file is designed to be open one day in front of a lawyer, a mediator, or an unemployment hearing officer, at which point the company will produce it and say, "Look, we tried. We warned them. We gave them a plan. They failed to meet it. We had no choice." You become a piece of documentary evidence in a case you did not know was being prepared. The second truth is one that HR professionals understand well and employees rarely do. A large share of performance improvement plans end in termination or resignation within 6 months of being issued. Industry estimates commonly place this figure around 70 to 80%. And while the exact number varies by company and source, the directional reality is stable. For many companies, the practical function of a PIP is not recovery. It is documentation. Inside the industry, the phrase for the underlying process is managing out. A decision is often made in a calibration meeting, sometimes months before a formal PIP document is ever issued, that the employee is no longer a fit. The reasons are sometimes performance related, but they are also frequently budget related, politically related, relationship related, or the product of a new manager wanting to bring in their own people. Once that decision has been made, the PIP becomes the mechanism through which a largely predetermined outcome is executed on a documented timeline. The meetings that follow, the goals that get set, the feedback that gets delivered, much of it is choreography. The word to hold on to here is pretextual. In a meaningful share of cases, the stated reason on the document is not the operative reason behind it. The third truth is where the predetermination becomes operationally visible, if you know what to look for. Read your PIP carefully. If the goals on it are vague, subjective, or measured against standards that do not exist anywhere else in the company, the document is not a performance plan. It is a trap. Phrases like demonstrate more executive presence, be more proactive, show stronger ownership, improve stakeholder perception, and communicate with greater impact are the fingerprints of a PIP designed to fail. These cannot be achieved in any objective sense because they cannot be measured in any objective sense. The evaluator retains total discretion. An employee can work 90 hours a week and still be told that their executive presence has not improved. If the metrics look more concrete, the second pattern to watch for is moving goalposts. The target on week 2 is not the target on week 6. The deliverable the manager asked for on Monday becomes the wrong deliverable by Friday. The third variant, and the most brutal, is the impossible workload. The employee is placed on a plan that requires them to produce at a level no one in the role has ever produced at, with fewer resources than they had before the plan began. Failure is the structural outcome. The plan is not asking whether the employee can improve. It is asking how quickly they will break. Every one of these patterns is a form of weaponization. The metrics have been weaponized against the person they are supposedly measuring. The fourth truth is the atmospheric change that almost every person on a PIP notices before the document is ever formally issued, and it often begins months before the plan is written down. It is the phase called quiet firing, and it is a slow, coordinated withdrawal of the conditions that allow an employee to do their job well. You start getting left off email threads you used to be on. You find out about decisions after they have been made. Meetings you used to be invited to now happen without you, and when you ask about them, you are told they were not relevant to your work, even though they clearly are. Your contributions in the meetings you still attend go unacknowledged. Praise that used to come regularly has dried up completely. Projects you owned are reassigned to colleagues without announcement. Requests for one-on-one time get rescheduled, shortened, or held in hallway conversations rather than the focused sessions that used to happen. This is recognition starvation, and it is deliberate. The goal is to create an environment in which continued presence becomes psychologically unsustainable before the formal process even begins. In the post-pandemic era, return-to-office mandates have been folded into this same toolkit. A manager who wants an employee gone can simply enforce the commute, the seating assignment, the in-person meeting cadence with sudden rigor, knowing that for a significant portion of targeted employees, this pressure alone will produce what the industry calls self-ejection, which is the voluntary resignation that costs the company nothing in severance, nothing in unemployment, and nothing in legal exposure. Task manipulation works the same way. The interesting work gets reassigned. The administrative residue gets piled on. The employee concludes that the job has changed and the job is no longer worth doing, and they leave, and the file closes with zero liability. The fifth truth is the one employees rarely have the vocabulary to describe, and it explains why people on PIPs often perform worse once the plan begins rather than better. For many employees, a PIP functions as an acute stressor, and the response is the familiar one. Sleep deteriorates, concentration fragments, written communication, planning, and judgment, the higher order functions the job actually depends on, get harder to execute under sustained stress. Researchers studying workplace termination and constructive dismissal have described the pattern under various frameworks, including the Integrative Trauma Recovery and Adaptation Model, or ITRAM, which maps the initial acute stress phase as peri-traumatic distress. The mechanism does not require a clinical label to be real. The employee is being asked, while destabilized by the process itself, to perform above the level they were performing at before the process began. The drop-off that management then documents is frequently produced by the plan, not revealed by it. This feedback loop is one of the least acknowledged features of the modern PIP, and it is one of the reasons self-blame is so common among employees going through it. Recognizing the mechanism is the first operational step toward engaging the process from a position that is not purely defensive. The sixth truth is the one that produces the most bitterness among employees who learn it in real time, because it disturbs a belief many people hold dear when they first walk into the building. Human resources during a performance process is not functioning as a neutral mediator. It is operating as a compliance function of the corporate legal and risk apparatus, and its working objective during a PIP is to ensure that the termination, when and if it occurs, is procedurally defensible. The HR business partner sitting across from you in the meeting, nodding sympathetically, taking careful notes, assuring you they are there to help, is documenting the conversation for the company's file. Anything said to them about the manager, about the process, about personal circumstances, about frustrations, can be evaluated for its utility to the company's position. Seeking mediation from HR during a PIP is in many cases a strategic error. The escalation is not to a neutral party. It is additional material in the file that will be used to justify the exit. There are narrow exceptions where engaging HR creates useful legal friction: documented discrimination, documented harassment, documented retaliation for protected activity, but a general appeal to fairness, a plea that the manager is being unreasonable, a request that HR intervene in the performance assessment itself, these are not interventions that HR is structured to deliver in most organizations, and they will not be delivered. The seventh truth is the one that changes the game for employees who understand it in time, because it reframes the PIP from a terminal event into a negotiation. Many large companies would rather pay for a clean separation than absorb the cost of a contested one. Inside corporate finance and HR, the relevant instruments go by various names, often described as a prompt exit package, or PEP, formalized through a mutual separation agreement, or MSA. The arrangement is a negotiated severance, typically accompanied by a general release of claims, in which the employee agrees not to pursue litigation in exchange for a defined sum, extended benefits, a health coverage bridge, and, in many cases, a neutral or agreed reference. The amounts involved are often larger than employees realize, and in most cases, they are negotiable. What creates negotiating leverage during a PIP is usually not the employee's performance history. It is what can be described as buckets of evidence, meaning the accumulated documentation of irregularities in how the employee has been managed and how the process has been conducted. Documented manager errors, inconsistent application of stated policy, evidence that similarly situated colleagues with comparable records were treated differently. Emails that contradict the performance narrative in the PIP, any indication of discrimination, retaliation, favoritism, or procedural irregularity, wage, hour, or classification issues. Each bucket is a unit of negotiation capital. An employee entering the separation conversation with organized documentation and a calm posture typically negotiates a materially higher outcome than the company initially offers. The company does not want the fight. It wants the signed release. The release is the only thing it is actually buying, and the price of it is negotiable. The eighth truth is the one that reframes everything at the jurisdictional level, because the legal ground under a PIP is not uniform, and assumptions absorbed from American employment culture do not transfer cleanly elsewhere. The United States, through the at-will doctrine, sits at the most employer-favorable end of the developed world spectrum. In Canada, the governing standard is closer to just cause, and the threshold is high enough that most terminations without negotiated settlements carry a meaningful risk of wrongful dismissal exposure. Courts there have awarded substantial damages where procedural unfairness or bad faith in the termination process was established. In the United Kingdom, unfair dismissal and constructive dismissal claims run through employment tribunals with defined procedural protections and statutory notice periods, and the cause of action simply does not exist in most American states. In Australia, the Fair Work Commission administers an unfair dismissal regime with compensation and reinstatement remedies. Across much of continental Europe, dismissal protection laws require substantive justification and, in many countries, works council consultation before a termination is lawful. The point is not that every jurisdiction protects employees equally, because they do not. The point is that the same PIP document carries different consequences in different legal systems, and the leverage held by the employee varies accordingly. Know the jurisdiction under which you are actually working. It often matters more than the language on the plan itself. That is the machine. The first rule is the signature rule. When the PIP document is handed over, the employee will be asked to sign it. The manager and the HR partner will present this as a routine acknowledgement. It is not routine. Never sign for agreement. Sign only for receipt. Write in your own hand next to your signature the words "Sign to acknowledge receipt, not agreement," and date it. The second rule is the offensive questioning sequence, and it should be delivered in writing by email within 24 to 48 hours of the PIP meeting. For each performance concern listed on the document, ask the specific dates on which the deficient behavior occurred. Ask for the specific, measurable standard against which performance is being evaluated, and the source document in which that standard is published. These questions are not aggressive. They are documentary. They force the company to commit in writing to claims that, in most cases, cannot be substantiated because the PIP was not built on a documentary foundation. It was built on a decision that was then reverse engineered into a document. The third rule is the subject access request. Where it exists, it gives an employee the right to request all personal data the company holds about them, which includes emails, internal messages, calibration notes, performance reviews, and documents in which they are named. The manager who said the PIP was about performance may have written an email 6 weeks earlier describing their intention to exit the employee for reasons that have nothing to do with performance. That email exists. Ask for it. From the day the cold shoulder is sensed, from the day the invitations thin and the praise dries up, begin keeping a performance log on a personal device, never on company hardware and never in company cloud storage. That log, maintained on a device the company cannot access, remote wipe, or subpoena without formal legal process, is the single most valuable document an employee will own if the situation goes to negotiation or to court. The employees who win these negotiations are almost never the ones with the strongest performance records. They are the ones with the most complete private documentation. The PIP is a weaponized document more often than it is a developmental one. In most of the cases that proceed to a formal plan, the outcome is already directional. The process is a negotiation, the document is a piece of evidence, and the company is more concerned about the file being built on the other side than the employee has been taught to believe. Sign for receipt. Ask for specifics in writing. Organize the evidence. Make the subject access request. Understand the jurisdiction. Keep the log off the company laptop. And stop mistaking the tombstone